And we are live. Yes, we are. I feel like I should say something like, "Good morning, Vietnam." No, it's not morning.
It's
Welcome
nighttime.
to Art Law Happy Hour. Yes, it's happy hour, people, unless, of course, you're in the Eastern time zones, in which case it's evening time, time to put the kids to bed. So this afternoon, from beautiful British Columbia, I'm Martha Rams. I'm the legal director of the Pacific Legal Education and Outreach Society, and we have a clinic, which is a pro bono clinic for artists here in BC, Artist Legal Outreach. And this week we start our series of art law talks over happy hour. Every week we'll be here talking about issues related to art and law. Tonight, but I'll start by reminding everyone we are here in particular in BC, where I am in Vancouver, on the traditional territories of the Musqueam, Tsleil-Waututh, and Squamish peoples. I did this morning as well. And we are grateful for their forbearance on our behalf. We are speaking today about something that's been coming up a great deal around cancellations of gigs, cancellations of events, both from the point of view of performing artists, whether you're a musician or an actor or a dancer, or on the other side, the festivals that have been canceled, the jazz fests have been canceled, the many seasons of theater and dance and music events that have been canceled, and the state that we're all in. So tonight we're welcoming to our happy hour event a lawyer from Ottawa, Byron Pascoe. He is a colleague with whom I've been working on the National Network of Legal Clinics for the Arts. He's a former board member of the Artist Legal Services Ottawa, and a lawyer with Edwards Creative Law in Ottawa. He represents a goodly number of both musicians as well as performing arts folks generally. So welcome, Byron. I hope that your day has been as sunny and pleasant as ours. And
It snowed.
Oh God. Well,
It was snowing today. Very large pieces of snow. Snowflakes.
Yes, over here it got up to 20 degrees, so I was on the beach. Sorry. In any event, I'm going to turn the screen to you. Welcome, and let's have a conversation.
Thanks, Martha. Pleasure to be here. So first thing I have to say, because I always have to say it when we start presentations, is the insurance disclaimer that this presentation, at least what I say, probably what Martha says too, is not legal advice, but rather is legal information. And if you have legal questions regarding your specific circumstances, to please consult with a lawyer. So that's the insurance disclaimer. Yeah, so as Martha said, I'm an entertainment lawyer. And I've formerly was a television producer, then was in law school, and I've been in entertainment law for about 6 years, a bit of corporate law before that. And so my firm and I were talking about some different topics to write about relating to COVID-19. And some of them relate to the options or considerations, or just, well, general considerations that performers have at this time, and also the concept of the force majeure clause. Some of these things that we've been writing about and thinking about relate to all different types of performing artists, some more specific to music, some more specific to production. But generally speaking, there's a lot of overriding concepts that people are thinking about at this very difficult time. We want to limit health risks while figuring out how to deal with pre-COVID-19 agreements during COVID-19 and how to plan for the future. When we had agreements for events that were going to happen this summer or fall, or just general partnership, general programming, who would have thought that we'd be in a situation like this? Well, some people thought about it because some people had clauses in their agreements that deal with situations like this. Other people just kind of rely on a handshake. Other people sign agreements that they don't even read. Most people don't read their agreements. They just assume that everything is normal and fine and nothing bad will ever happen or weird will ever happen, or something will happen that would be whereby it would be relevant to know what you agreed to. So, this is kind of a situation whereby it reinforces the value of having agreements relating to your professional relationships that you understand, that have been negotiated to meet your specific needs and that are clear. Because if you're relying on an agreement that isn't clear or that isn't in your favor but should be, or a variety of other things that should have happened that didn't happen, this is kind of a, you don't want to have a loss generally to learn a lesson, but a general lesson from a contractual perspective in these times is just a reminder that it's important to read and review and understand the agreements that you're entering into with other people in your professional career. So, some of the things that I'm seeing are presenters who've had to either cancel or postpone events. I work with festivals. I more so work with individual musicians and artists, and they're seeing gigs cancel. There seems to be a lot of events that are being moved to the fall, but who knows what the fall is going to look like. But general things that I'm seeing are potential arrangements or situations or just kind of new activities that are being paused until we all know what the heck is going to go on for the next few months. And those things may come back, when this is over. I don't know if it'll ever be over, but those things may come back. But in the meantime, there are events and programs that were supposed to happen, by now or coming up, and people are trying to figure out kind of, what to do. So there were three main questions that I wanted to go through. That are also highlighted in some written materials that we'll be sending out later this week or next week. And the first one relates to the rights and obligations that a performer has to the venue that they expected to play. And we'll talk about that question kind of on both sides of the fence, because it's important to think about all the players involved, and some people in this conversation may be the performer, and some may be the venue or some other related party, including a service provider. Second question is about what a individual's obligations are to other people in addition to the specific venue or event. And the third is about force majeure, which in addition to being we'll get into that. We'll get into what force majeure is all about and whether it's something that's relevant for you. It may or may not be in the relevant agreement that you're thinking about. So, to rights and obligations that someone has to a venue that they expected to play. So the context here, generally speaking, is that you have, let's say, a musical performer who's expecting to play at a venue on a tour or a one-stop venue performance. But it could also be someone, for example, who is expecting to have an art show at a venue to showcase their art for a month. Or it could be, a theatrical show or a dance company. You have a performing company that's expecting to do a show in different venues across the prairies or in Eastern Canada or wherever, over the summer into the fall. So, when I speak about performer, we can think about it as either an individual, let's say a singer-songwriter, or a band, or a visual artist, or a dance troupe, who's expecting to play at a venue, whether that's a performing arts venue or kind of a dingy bar or somewhere in between. So the first question that I think that this individual, this performer, should think about is whether they have a written agreement with the venue. Many don't. In my experience, I've prepared some agreements for artists when they go to venues. But the first question is, do you have an agreement with the venue, formal or otherwise? Which leads to the question really of, what makes an agreement? Is a verbal agreement, is a verbal discussion an agreement? Is an agreement over, Facebook or Messenger or text? Or, these are all binding agreements. There's a lot of reason why someone would want to have a written agreement as opposed to a verbal agreement over the phone or a few texts. So I wasn't sure if that was someone jumping in. But the first question really is, again, is there a written agreement? If not, is there any agreement? Was there an email exchange? And so when you're thinking about what your rights and obligations are, the starting point is, well, what did I agree to already? So if there wasn't an agreement, then the question is, okay, well, now what do we do? What are the types of things we should be talking about with the venue? If you do have an agreement, or if you didn't have an agreement and you were already paid some sort of guarantee from the venue, then are you supposed to pay it back if the event is canceled? If it wasn't paid, but it should be paid, what are the obligations? There may have been a specific fee that was contingent upon the event happening or not happening. There are a variety of different scenarios whereby there's a guarantee involved, a fixed fee of what you're being paid. And, preferably for the performer, there's a fee paid to you no matter what, even if the event doesn't happen. Now that's kind of, best case scenario. More likely if the event doesn't happen, you're not paid anything. And if you were given a guarantee and you were already paid it, your arrangement may require you to pay it back. But, whether, I don't know what the arrangement is because it depends on what you agreed to. In kind of the music world, a lot of guarantees are paid about a month before the show happens, or at least part of the fee is paid about a month beforehand. And so, if your event is in 4 or 5 months, there's less likelihood that you've already gotten paid your guarantee. Whereas, if your event was supposed to happen the first week of April and you got paid your guarantee the first day of March and the whole, shutdown happened closer to mid-March, then it's possible that you already got paid something that you may or may not have to pay back. So, the bottom line on this is just looking, again, this all goes back to reading what you agreed to or looking to see what you already agreed to, if you agreed to anything. But one of the things to look into is, how does this impact any sort of guaranteed fees that I was supposed to be paid or already paid? A related issue is the cancellation policy. Does your arrangement give the venue the ability to cancel your show without any liability? For example, a certain amount of time before the show takes place. What if the show has to be canceled because of a reason outside of the venue's control, which we'll get to force majeure in a bit. Does the cancellation policy allow the venue to cancel but still have to pay you some sort of minimal fee, sometimes called a kill fee, but something to take it to compensate you for the fact that you set aside that date or dates for that venue? Generally speaking, kind of the more leverage the performer has, the more likelihood they're able to get some of these entitlements in their agreement in the first place. And the more leverage that the venue has by being a venue that a lot of people want to perform at or be connected to, if there was an agreement, ideally for you as the venue, the arrangement was that you can cancel on as short a notice as possible without any liability to the artist. Some people kind of meet somewhere in between, and many people just don't have anything discussed because they have no agreement, or they just assumed everything would be fine, and it just, again, just don't have an agreement. So the point of these considerations is to look at the arrangement in whatever form they were. And again, they may be in an agreement, or they may be on some sort of terms and conditions on a website that the venue had given to you that you never read, because no one ever reads that stuff. And the venue may have some terms and conditions that some intern wrote 10 years ago that are completely non-favorable, because maybe the intern was, did for some reason, for some reason the terms and conditions may not be as favorable as you would like venue because of whatever reason, and you never looked into it, and maybe now is a good time to look into it. But generally speaking, the cancellation policy. What is the cancellation policy? Who is it favorable towards? Is it reasonable? It doesn't have to be reasonable. It just has to be agreed to by the parties. You're allowed to enter into an agreement that's not reasonable. It's not preferable, but it happens all the time. So, what you want as a venue and as an artist or performer is a clear cancellation policy that answers the questions of how do you deal with either party wanting to cancel for a specific reason or for any reason, and what happens if the event has to be canceled because of a third party reason. For example, the government saying you can't have people congregate more than whatever people like. So I'll leave it at that for cancellations. My next point here is, what if the venue insists on proceeding but you don't want to perform due to health concerns? Well, I wrote that point before some of these shutdowns were happening, but it is possible, especially when we're kind of transitioning back to normality, whenever that is, that a venue may want to continue, and you as the performer may feel uncomfortable about that, for very valid reasons. So, how do you deal with that? And I don't know. It depends on the circumstances, but that's something to think about as both the performer and the venue. Okay, what happens if the venue wants to cancel? What happens if the performer wants to cancel, but the venue doesn't want to cancel? What happens if we're both told we can't go on? Those are the different scenarios to think about, and depending on which party you are in the formula, there are going to be different elements of this kind of thing that are favorable for you. So as the venue, you're going to want to have as much control as possible and have the least amount of liability as possible to the performers. And as a performer, again, the more leverage you have as a performer, the better you can negotiate your arrangement. Preferably, if you want to be there to do the show, if you're ready, willing, and able to do the performance, and you show up, I'll get to those words later. They weren't kind of picked randomly, but if you were, again, if you as a performer feel that you want to do the show, but the venue is not allowing you, then how do you deal with that? So those are some considerations there. Right. So the related comment to those things is that if the show, performance, event is far enough away that it might potentially happen, but maybe not, and you don't have an agreement regarding any or all of these things, you may want to just have a very open discussion with the venue, or other people that are performing at the venue, or other venues that you're potentially going to travel to, about figuring out how to deal with these types of issues. And I'll get into a bit later in the conversation, I'll get into some ideas surrounding that. So I'll jump to just the next one, which I'll maybe a bit shorter, is about obligations to other people. And so when I wrote this originally, it was in the context of a musician, but it really works towards any kind of performer. And one of them relates to the people that you are performing with. What are your obligations to the other dancers in your troupe? If you're the lead person, who's if you're the leader of the pack, so to speak, but you have other people that are part of your performing crew, what are your obligations to them? Do you have guarantees to the people that you're working with that are in your dance troupe or in your band? How do you, as the lead performer or lead relevant person here, how do you reasonably and contractually get away with, maybe getting away is a bad word or maybe not, but how do you get away with not having to pay people if you aren't paid? Other people rely, obviously if you're the single performer, a lot of other people's incomes are being impacted by whether you're getting paid or not, and whether you're performing or not. Relating to this in the music context is about having side artists, whereby, let's say there's a lead performer and you have side musicians, but similar for any other type of performing arts. A related concept is pay or play, meaning that you're paying someone even if they don't end up doing the thing, even if they don't end up performing. There's still some sort of minimal fee. And I mentioned that earlier in the context of like a kill fee, but preferably if you're the lead performer, your arrangement with the people in your group, however you want to define it, indicates that they're paid if and when you're paid, which is normally reasonable, but maybe sometimes there's different challenges with the way that the group is set up, or just the logistics generally, whereby there are some fees that you're somehow responsible for. The farther away the performance is, or the show is, that gets canceled, likely the fewer the costs that have been incurred by people, including relating to travel and accommodations and other things. But either way, the general concept is, preferably if you are being paid by venues and you are responsible to pay other people, preferably your written agreement with these people that are working for you provides that they're paid if you're paid, and also when you're paid. So you aren't obligated to pay people before you're paid. If you're working with a manager, again, that's or an agent, which spans any area of performing arts. If you're paying that person a commission, that may be how you compensate that person, or perhaps you're paying that person a monthly consulting fee. If you're paying that person a monthly consulting fee with the expectation that you're going to be on tour all summer and fall, how does that impact the monthly fee that you're supposed to pay your manager or agent or whatever other member of your team? So preferably what you thought about, a year ago was to say to your new manager, okay, so I'm paying you, random number, let's say $1,000 a month between, April and October, because I'm assuming that I'm going to be on tour those times. And then your entire schedule gets canceled, and you have an obligation to your manager to pay her $1,000 for 6 months, per month for 6 months. So again, kind of preferably in that arrangement, you thought about having some sort of way to at least lessen your obligations to the other person if all your income is being lost. The last point relates to the same thing, essentially about a booking agent. So whether it's a booking agent or a manager, depending on how they're compensated, you may be in a bit of a pickle, and hopefully, people are understanding, but the reality is that, your agent or manager relied on income from you, and, you need to kind of figure out how you're going to get through this together or not. But the starting point is, what are your contractual obligations to other people, at least as a starting point to figure out how you want to deal with it. Related comment is that it is preferable to arrange to formalize your arrangements with your professional partners early in the relationship rather than later. But many times that's not what happens. Many times when I'm looking at a manager agreement or a band agreement, the people have been working together for a long time and, finally want to finalize their arrangement. So it's never too late to organize your arrangements with the people that you're working with. Better late than never. So I'll leave it on that point. And then one final point about this general set of considerations is about the fact that even if your contract or your arrangement gives you the ability to, for example, not pay your manager if you didn't go on tour. You might still want to pay someone something that you aren't required to legally or contractually. You may what's called waive your rights. You may give up your rights for something that gives an advantage to somebody else. But if you're planning to give up some of your rights, you want to be clear about the extent to which you're giving up your rights. You may want to give someone more than they're entitled to for a month or a few weeks, but you don't want to be obligated contractually to have to continue to give someone more than what they're entitled to. So if you're ever waiving rights, you want to clarify what the arrangement is. There's a relevant clause in most agreements written by lawyers and not by the internet about this, which essentially say that if you waive your rights once, it doesn't entitle the other person to have the rights be waived all the time. So in a general agreement, there would be a clause about that. But again, generally speaking, if you're giving someone more than what they're entitled to contractually, just be sure that everyone's on the same page and in writing about, the extent to which for now you are giving up your rights to whatever it is you're giving up. And the third thing I wanted to talk about was about force majeure. So in contract law, force majeure, so just we're on the same page, force says F-O-R-C-E, measure M-A-J-E-U-R-E. Sounds like a action film or something written by a lawyer who's had enough of law and wants to get into filmmaking. So in contract law, force majeure refers to events that are out of the control of the parties and that may make the performance of the contract difficult or impossible. So the underlying principle of a force majeure clause in an agreement is that no party to the contract, no one involved, neither of the people or companies involved in the contract should be held to its obligations if the performance of those obligations are prevented or delayed by events that are both unforeseeable or either depends on the clause, but that may be either unforeseeable or beyond that party's control. So the first question I have about force majeure in this context is there a force majeure clause in the relevant agreement that's being discussed between the parties? There might be, there might not be. If there is a force majeure clause, is something like COVID-19 covered within so that it's within the scope of what the force majeure is? It might be, it might not be. It might specifically be excluded. It could be that, however you want to define coronavirus and like health-related issues or government-imposed lockdowns or shutdowns or downs or whatever you want to call it, that may be excluded from what's considered a force majeure. It's likely included if there's a laundry list of items that would be within the scope of force majeure, but it might not be. But again, do you have a force majeure clause? Yes. Okay. Is COVID-19 covered? Yes. Okay. So if you have a clause, force majeure clause, if COVID-19 would be considered a force majeure, then what are the implications of one or both of the parties relying on COVID-19 being a force majeure? It might be that neither party is so let's say that this is a dance troupe who's going around city to city. They're doing 10 different cities over 13 weeks in the summer or whatever, or not whatever, but like from May to June or to July. And the agreement might say between the dance company and the different venues that if there is a force majeure, which includes but isn't limited to anything relating to health issues or being unable to be open legally or potential risk of health infections or not, maybe not infections, but health issues, blah, blah, blah. Okay, so now we know COVID-19 is included, and it might say that if either party relies on this force majeure clause, including but not limited to COVID-19, that either party can cancel the event and neither party will be obligated to perform its duties. So what are the dance company's duties? It's to perform the show. And what are the venue's duties? It's the duty to pay, among other things, pay the dance company any guarantees or any other sort of compensation. So if the venue wants to not have to pay the dance company and not have them in because they aren't able to open their doors, they would say to the dance company, okay, so we're relying on this. Again, this is all dependent on what the clause says, but generally speaking, non-legal information purposes only, the venue might say, well, because COVID-19 is within the scope of this force majeure clause, we're saying that the event is canceled and we aren't obligated to pay you and you're not obligated to pay us. So the dance company now says, well, now what do? We've paid for all these expenses. We've taken time off, other things. Is there any way for us to get any of the money that the venue is supposed to pay us? And, in that situation, it seems pretty cut and dry that there aren't any obligations at all. But it depends on what the contract says. The contract might say that the guarantee that, 15% of the guarantee is paid no matter what, even if the show was canceled, including but not limited to a reason for force majeure. Now, the venue is never going to, propose that to the dance company, but the dance company may, moving forward, or may have a year ago, thought to include some kind of clause that would allow them to be paid something. Now, even if the contract gives you the lane to access some of the money that the dance company would pay you, doesn't mean the venue's actually, sorry, even if the agreement allowed for even if the agreement said that the venue had to pay a certain fee, even if the event is canceled, it doesn't mean that you could just, walk into a bank and take the money out. Like, they still have to actually pay you, and they may push back on paying you because they don't have any money from the fact that there aren't any shows. So then you're in a situation whereby you may have to, look at all your options, including taking a look at what the governing law is and what the dispute mechanism provisions are of your contract. All that to say, the question is, is there a force majeure clause? Is this included? What is the impact of it? Another potential situation is that the force majeure clause might say, yeah, either party can cancel the event, or terminate the agreement, or cancel the obligations of all parties. But if the performer is ready, willing, and able to perform, then they're paid their guarantee, or they're paid something. So that's a very artist favorable situation, because if the dance troupe, or maybe it's a one-person show, if that person shows up to the venue on the day of the show, whether that's legally allowed in that jurisdiction or not, if they show up and they get take a little selfie of themselves that's date stamped on that day, they're like, well, I was here, so you owe me whatever it is you were to owe me. So that's a relevant consideration on both sides, is if your force majeure clause gives the performer, whether it's you or the other party, the ability to override the way out from paying you. So you want to read your force majeure clause if you have one. If you don't have one, if you don't have a force majeure clause, and your event is several months away, and you want to have some clarity about the situation, and whether you're the event or whether you're the performer, you may want to contact the other party and say, listen, let's be honest here. We have no idea what's going to happen with this event. It's 6 months away, or 5 months away, or whatever, or a year away. I mean, this thing could last a long time. Hopefully not, who knows? So let's get on the same page, other party, about how the heck we're going to deal with this thing. So first off, if we don't have a written agreement, maybe it's a good time to clarify some terms, but let's just talk specifically about this force majeure thing. So maybe we want to agree that if the event needs to be canceled or postponed for a long time, that either one of us can cancel this without either party having any obligations. And either party can do this if they just feel like it's not appropriate time for the event, or if we're told we can't have it, or whatever reasons both of you want. And kind of depending on the circumstance, you may want to have very broad, you may want to have a very large set of reasons to cancel it, or you may want to have it be very narrow. It kind of depends, on the circumstances. And then, so let's say either party can cancel for a broad set of reasons relating to a health risk, including but not limited to the coronavirus disease, including but not limited to COVID-19. Lawyers like to say including but not limited to, because that's just kind of, I don't know, we like that. But also it just kind of, gives examples, but says these examples are not the only examples. These are some examples, but it's not the only reason. Because as I forget if I said to this kind of before we started the webinar or since then, this may come back as COVID, 20 or whatever they call the next thing in a year from now. And so you want to plan for all of the potential situations that relate to this, but also other viruses and other health issues. Anyway, so if you've confirmed that the parties agree that under all these circumstances, either one of them can cancel or terminate the arrangement, then what? Maybe your arrangement is that neither party will be required to fulfill any obligations outlined in the agreement. Perhaps you might say that neither party will be liable to the other for any damages, any expenses, any fees relating to the event. And it may also say that the programmer is not responsible to pay the performer any guarantee, any compensation, including but not limited to transportation and accommodations, unless those expenses have been pre-approved, and so long as receipts are given afterwards to demonstrate those expenses. Because as the programmer, you may want to give a little bit of slack to someone who's paid for some stuff, and you may already have the budget, depending on where you are in Canada or beyond. You may actually still be getting some grant money for your program. You may still be able to cover some of the charges, and the venues don't want all creators to go out of business. We all want the ecosystem to keep working, but we also are on limited resources, so it's a balance as always. But either way, so that's one of the ways that you may arrange with the other party. And you may also arrange that if there's any deposit, that it's returned back to the venue. And then the final thing I'll say about this type of situation is that you may want to have a mutual release whereby both parties are confirming that they're not going to go after either party by way of a demand or a lawsuit in any way relating to the event, including but not limited to relating to COVID-19, blah blah blah. Because you want to clarify that we're not going to. First off, we're not going to have any obligations to each other, and also we're not going to sue each other for any reason relating to the show or the event. So again, kind of the context of those last comments is to say, is thinking about an event or a program or an initiative that's later on that may or may not be impacted, whereby you haven't yet thought about the possibility, or you haven't yet, you don't have anything in writing or even verbally about how to deal with this type of issue. And now is the time where you may want to start thinking about how to deal with this issue in order to get clarity, and in order because you may think that you're a little bit exposed legally or otherwise if you don't deal with it now. And instead of putting your head in the sand, you want to be upfront with your partner, your presenter, or your venue about how to deal with these real life issues. Now, many people are in situations whereby they didn't have an agreement. The time is just lost. Like, this didn't have any time to deal with this because the time was so short between when things shut down and when the event happened. But there are, a lot of things happening later on. And all of these comments hopefully are relevant for, post COVID-19 land, whenever that happens, to deal with these situations in future, because, some people have dealt with them already in regards to force majeure clauses. Some people haven't. But it's a time to kind of reflect on the agreements that you're using in order to think about these situations that are, that may come up in future. Now I feel like I'm rambling a bit, so I'll end it at that.
Yeah, I think,
you can jump in.
Thanks, Byron. I think actually that's, listening to you wasn't rambling at all. It was very much taking us through the vagaries of how contracts actually work in practice, and that a lot of this is open to negotiation. And it's really important that there is a real tendency in this space for people to just assume that the contracts are going to be something that they don't have to read or something else. And I mean, it's, the reason that many of the legal clinics exist is a lot of our time is actually spent explaining contractual terms to individuals who are new to, or are not so new, but who've looked at, are in a situation and realizing they've signed a contract and they don't have a guarantee, for example. And that's something that, even for many artists, I think just knowing that you can ask for a guarantee, or particularly moving forward, since there's a great deal of unknowns here, is saying, depending on the context, depending on the presenter, depending on the kind of presenter you're talking about, but there is a willingness to meet people halfway. And this is a sector that is very interdependent. And I think what I am hearing from folks in the performing arts world is we're trying to figure out ways to get artists paid something. We realize that we may be actually better able to absorb some of this than some of the individual artists and companies that we've been working with. So I think it's always a two-way street, and this is a way of, in fact, this is 1 hour of what really should be multiple days. But there is a question from an individual, an attendee, about saying, I think it's an interesting question. Can we ask organizations to rewrite contracts or agreements based on new information and developments with COVID-19? Many of these agreements were written months ago before the shutdown. And I would assume, like, let's take an example. You've agreed to perform at, the Jazz Festival or the Ottawa Blues Festival. And that now it's not, or maybe it hasn't been canceled yet, because there's still hope that it might proceed. What is it? Should an artist seek to have the contract reopened? How likely is it that, we're going to be able to do that?
Well, as you know, the answer is always, it depends.
Yeah.
But so a few kind of general thoughts about the question and your prior comments. And I'll start with the prior comments, in that a lot of people, especially performers, are told that the agreement they're being asked to sign is standard and therefore non-negotiable. And my comment to that is that everything's negotiable. So just because you're told something standard, and it works the other way too. If a venue, is talking to the artist that they want to have in, or again, the dance company or whoever else, and the dance company says, well, we have our agreement, our standard agreement that's given to every venue. The venue can also say, well, great, it's standard for you, but we're still going through the terms and making sure they're consistent with our needs too. So there's that. And if both sides, if both parties, or all three parties, or however many parties there are, if all the parties to an agreement agree to having it changed the agreement, then they can change the agreement. If one person unilaterally wants to change the agreement, you can't do that. You have to have all the parties agreeing to the change. Now, is it likely that the agreement would change? Well, the starting point is, well, what does the agreement specifically say about the situation, and how do you, think that it should be changed to make it more reasonable? And I think the starting point there is to say to the other party, based on our agreement, here's how our agreement deals with the situation. At the time, we thought it was reasonable or enough to sign this agreement, whether we read it or not. But today, the new reality is this pre-COVID-19 agreement is going to lead to some unreasonable outcomes during COVID-19 times. So, and here's my specific challenge with how this agreement impacts me and this company and these other things, including that we may not survive, and therefore we can't come back to your event every year and put on a good show for your attendees who expect us. So in light of that, here's what we're suggesting as a change to the agreement to reflect the new reality. What do you think? And again, as you said, Martha, it's a negotiation. Everything is negotiable. That doesn't mean that the person has to agree to it, or the company or whatever has to agree to it. But I think the starting point is to kind of look, read the full agreement that you have, if you have one, figure out, what the impact is of this situation, putting it through the machine of that agreement, and trying to convince the other party that it should be amended to reflect the situation. And that, I spoke before about waiving rights. I mean, it may be that certain clauses, certain issues maybe maybe rights are given up this year, but not every year afterwards.
What about the problem in the scenario that you just described of, well, a venue then saying, well, you in asking for this is an anticipatory breach of the contract that we have with you now, and we're going to elect to terminate?
Depends.
Yeah.
If you want to kind of elaborate on it, if you want to kind of create a...
Yeah, no, let's not go down that rabbit hole.
Okay.
That
sure,
was a
okay.
very legalistic rabbit hole that I took us down.
So,
I just thought to myself, I could see a way of getting out of that scenario if you really didn't want, if that artist was actually one that you might actually want to let go because they have costs associated with them that would put the whole event at risk, right? You've got, there's artists that are, very inexpensive, or, it's a matter of the bottom line, right? And you say, oh, well, you really want to change this? Well, then, this is actually in breach of our agreement. And anyway, I'm not going to go down that rabbit hole.
Sure.
Because there's another question here that I want to take, or we'd like to get to before we have to go have dinner or pass out, whichever. So the other question here, which is actually quite interesting because I think it does come up. We work with artists who are more often than not immune compromised, and our organization has events and exhibits with third-party organization spaces. We and artists are much more conservative about returning to public space. However, some exhibition spaces want to move forward as soon as possible, keeping events open, or imposing hefty cancellation fees, which we did agree to in writing prior to COVID-19. How can we renegotiate?
Yeah. I probably want to read the question again in full, but how do you negotiate that? I mean, it really depends. I hate to say it depends on the circumstances and the leverage that everybody has. And here, let me just, I just want to see if the message is in the chat here, because I think I missed part of it.
It's in the Q&A.
In the Q&A, okay.
Yeah. So, I mean, one of the interesting things about this is that, for what it's worth, like, and actually there's a certain lack of clarity, is who is imposing the cancellation fee on whom? Is the cancellation fee being
Yeah.
imposed on the artist, which would be somewhat
Mhm.
unusual, or is the artist going to receive a fee notwithstanding the cancellation? That would be the more common thing, the sort of kill fee,
Mhm.
if you cancel the event less than 2 weeks ahead of it going forward, then the fee is X. If you cancel the event a month ahead of time, the fee is Y. Assuming that you've got a performer or a company that has had the presence of mind to include that in the contract. I think we will see many more of those going forward, but in my experience, actually, most of the standard like CATA contracts don't even speak to cancellations
Right.
in the way that you might in music, for example.
So one of the considerations here in the context of the space wanting, I think I mentioned this kind of earlier on in the remarks about a situation in which the venue wants to proceed, but you as the performer did not want to proceed because you're feeling that you're just not ready and that there's too many health concerns. Well, it kind of depends on when this is all happening and where in the country or the world you are. But you might be able to get some sort of, government related, well, I mean, it kind of depends on what the status is of the shutdown. But let's say everything has been lifted. I mean, there may be some kind of government imposed ways to deal with some of these things. Kind of like a government doctor's note that allows for people to have this as kind of I hate to use the word excuse, but a reason not to be a government related reason to rely on. But
I think, yeah, I mean, one of the ways I would approach this, if you're trying to renegotiate, is by identifying, for example, when the series of shutdowns occurred, there was a point at which venues where 50 people or less were congregating were allowed to continue. So in Vancouver, the fire hall remained open. The Cultch went down to 50% capacity. And the Van City Theatre also went to 50% capacity with physical distancing. Now, if film is an inert object, so that's not an issue. But in the situation in the fire hall, I was really interested in it because it's a very, very intimate venue, and even 50%, there's a lobby area that's actually very, very small, and they would not have been able to maintain the distancing. So my approach to the situation, without being heard to be casting any aspersions on the fire hall per se or any other venue, is to say that, if you know the venue and you know that they would not be able to maintain appropriate physical distance or maintain the health and safety of the immune compromised artists or other disabilities or whatever, then I think you have to put that in writing to the venue as soon as practically possible and say, well, we understand that we are now in this phase in of events and that you would like to continue. Our particular cohort of artists are individuals that are going to require X and Y in order to proceed. And for example, even though the venue can hold 200 people, that the actual sales of the tickets would be 50 or 20. And if you actually got down to the brass tacks of saying only 20 people could come, well, it's no longer financially viable for the venue to proceed. So, then, I mean, you're in a tough spot because people then might say, well, you have to come, or, we're going to take you to court. And, I think in the reality though, very few artists, have you ever, I mean,
So,
how
but
many
this,
people get taken
this,
to court over this stuff?
well, not very often because people can't afford
Yeah.
that process. But I think now that I'm reading the question here, so there are three different parties in this situation. There's the artist, there's an event organizer, and a venue. And the venue has to deal with the event organizer. And the venue is saying, if you cancel the event, you event organizer, then you have to, still pay for the space, even if you're not using it. But you don't want to use it because the artist doesn't feel comfortable, and we don't feel comfortable with having the show go on. Right. So, I mean, in that situation, you're kind of hoping that there is a force majeure clause that you can rely on as a way to, depending on how the force majeure clause is drafted, to get you out of it.
Yeah.
Part of the negotiation too is that, you may be teaming up with other people who are renting the venue and saying, listen, like, none of us are going to rent your space anymore if you aren't going to be, somewhat reasonable with us. And just kind of figure out everybody's interests and how to lead to a place where everybody's, compromising in one form or another.
Right.
But yeah, I mean, it's obviously a challenge, and you wish you had a force majeure clause that was relevant if you are ever agreeing to cancellation fees, because that's kind of exactly why you would do it. I mean, if the artist had died, and it was not COVID related, but like, if you're having a performance and the artist passes away, and it's supposed to happen in 2 months, what does your contract say about that? I mean, it's not going to mention if artist dies, but like, the context is, if for a reason outside of the control of the event organizer, they can't use the space, preferably there's a way to not have a hefty cancellation fee attached to that cancellation.
Yeah.
How is this different?
Yeah, and the other thing that comes to mind is the possibility, since this is a BC related question, of looking to WorkSafe. While there may no longer be an edict from public health, there might well be some continuing concerns raised through WorkSafe around just exactly what is safe, what is a safe workplace, and it would be an interesting question. And unfortunately, this is, we're kind of running out of time here, but this is one of those questions that, may involve a lot of different players, and knowing exactly, in this kind of scenario, what does WorkSafe actually do for us in this situation? Is this a situation, and this would, I would say, knowing the company that's asking the question, I would say, I would also take this to Act Safe as an ongoing issue. Is, this is likely to come up again, because we may be living in a situation where we're living with COVID-19 without being locked down, so to speak, and with the allowance that certain amounts of congregating can happen, and still that congregating will put certain categories of people at risk. So who do we go to? And now is the time to be asking, who will tell us how we take care of our artists? Which I think goes to your question, Sarah, at the end of the day, which is, and I would say start looking to WorkSafe, Act Safe as another option, and really, and even public health. Introduce yourselves to public health and say, we're looking forward and we need to know how to work with folks. So it's 6 o'clock, and I'm going to thank Byron for participating, and to thank also the City of Vancouver Culture, who's given us operating funding so that we can do ongoing activities like this, and the participants who came to us this evening. And I look forward to seeing you again. And Byron, thank you so much.
You're welcome.
We will
Pleasure.
we will be circulating the fact sheet, and I encourage you to, you know, check out his blog on the Edwards Creative Law website, which a link will be provided as well. So have a nice night, everybody.
Stay safe. Take care.
Thanks, Byron.
Thank you.